Hello students, I am Dr. L.K. Das, Assistant Professor of Sociology at the Department of HSS, IIT Roorkee. Welcome to another lecture of the NPTEL course Power and Politics in Contemporary India, a Sociological View. In today's lecture, we will discuss something that is controversial, something that is interesting because it is controversial. At the same time, it's also something that we confront on a day-to-day basis. It is law and the different characteristics and different variations of law and versions of law that we experience every day. Now in today's class, we'll specifically discuss about legal pluralism and how sociologists, particularly as part of sociology of law, understand legality, legal pluralism, and what is legal and law. So in this, we'll see how law and how law functions in a particular society, how a particular type of law is conceptualized, and at the same time, what could be the variations within a law or within laws where we call them as legal pluralism. Legal pluralism, one of the key definitions is that it refers to situations where multiple legal or normative orders coexist within the same social field, subjecting individuals to overlapping sources of authority and regulation. This is quite a mouthful. You may or may not remember it in full. What is significant here to understand is that any situation where you have multiple legalities or there is one individual and this individual is subjected to multiple laws L1, L2, L3. Now what could be L1? L1 means that you, as a citizen of India, you have to follow certain rules. For example, you cannot get married before the age of 21 and 18 whether you are a male or a female. Second, so this is not negotiable. Second, but if you are a Hindu, you can get married according to Hindu law. If you are a Muslim, you can get married according to the Muslim personal laws. Or if you are a Hindu and getting married to a Muslim, then you can go through a certain other kind of law. Now that is also part of this differential aspect of legalities. The same applies here in terms of inheritance. Now if it is primogeniture, then probably only the eldest child, or most often than not the eldest son, inherits the property that comes out of this marriage alliance. If it is not so, then it could be the different aspects. One of them could be that maybe the eldest son gets 50%, the second son gets 20%, the third son gets 20%, and if there is a daughter, she gets 10% of the property. Now if we follow this system, that means our lives are governed by different aspects of legalities and different laws, and these laws at the face value may or may not speak to each other. Otherwise, now let me come to the situation why I call something as controversial when it comes to legalities. Now because we have started with the issue of marriage, what if somebody has got married with proper legal systems, but as per the Hindu religious code, but does not want to go and register their marriage with a legal court? So what happens at the time of divorce? Because now on paper they are not married, but through the religious and cultural practices and customary practices they are married. So that is the reason why the Constitution of India recognizes legal pluralism. It requires us to understand that pluralism may include state law, religious personal laws, customary practices, informal justice systems, special constitutional provisions functioning together within society. And because each one of these laws are embedded in the social fabric, in the social structure, that is the reason why they can coexist, sometimes at conflict with each other and sometimes in coordination with each other. So in other words, whenever we try to understand legalities, we have to understand L1, L2 and L3 as forming part of a unified whole. Many a times L2 takes precedence over L1, that is, your personal religious law or religious personal law takes precedence over the kind of laws that are there or that are created by Indian courts. Sometimes you have customary laws which govern your neighborhood, your caste network, your religious network, or what is happening inside your family itself. So at each one of these points, we have to understand the pluralism. Now this pluralism, as we'll discuss in a moment, can be both positive as well as negative. L1 and L2 could be contradictory to each other. One contradiction that I can highlight here is, what if there is an inter-caste marriage? Both person A and person B belong to two different castes or two different jatis. Now when they get married at a registrar's office, they are doing it legally. There is nothing illegal about it. So L1 is fulfilled, but the elders in their jati or in their caste network doesn't approve of this alliance. So what they do, they can pass an order calling for the nullification of this marriage. Now nullification can only happen through legal means. Or second aspect is that if A is upper caste and B is a Dalit, get this B killed. That is why we call it honor killing. Now this is significant because honor killing could be a part of a customary law, but this customary law is in contradiction to the L1 or to the legal rational law on which this country is being governed. That is the reason why Indian Penal Code does not approve of the so-called honor killings, and anybody who is part of it can be brought to the books and can be penalized for that. But what if rather than killing this person B, this alliance A plus B, it's socially boycotted? Now social boycott is something that happens in the gray zone that is there between L1 and L2. So this is the places, or these are the places where legal pluralism works, and it could be governed through local practices, moral orders and non-state authorities. A non-state authority could be a caste network. A non-state authority could be a temple, could be a mosque, could be a church, so on and so forth. So we understand this in our day-to-day lives, but as students of political sociology, we need to look at it from a sociological point of view as to why something is happening, who is gaining, who is losing, who is creating some of these laws, even if in the name of legal pluralism. Sociology of law examines how law functions as a social institution, shaped by material conditions, cultural norms, and power relations rather than merely a neutral set of state imposed rules. So, what does this mean? It means that in our society, whether it is India, whether it is any other country, is governed by the inequalities such as caste, class, gender, region, so on and so forth. Now, if that is the case, then how caste determines your access to law, how class determines your access to law, how gender determines your access to law, and how the region determines your access to law. Now, access here is significant because when I say caste, that means, as we'll discuss in a moment, caste, who are the representatives of a particular caste. Do you think that all castes or all jatis have equal representation in legal bodies or have equal representation in the way law is understood? One of the key highlights of Indian judicial system is that most of the judges, whether it is Supreme Court of India, state high courts, or even district and sessions courts, they happen to be from upper caste. And not just that they happen to be from the upper caste, but they also happen to be from upper middle class. And third most important being that they also happen to be male. So, in this kind of a situation, what we witness is that how this law is created, how this law is understood, and how these legal frameworks are interpreted is determined not just by a fanciful idea of law above everyone else or law that governs everybody in the country, rather how it impacts each group differently. That is another reason, and it comes from a position where we understand that most of the people who are in prisons are from lower caste, lower class, and something that is not mentioned here are from the religious minority groups. And even those ones who are from religious minority groups, they also are part of low caste Dalits and low class or low middle class. Why is it so? It is a sociological question. It is not just a question of legalities or it is about how constitutionalism works here. Rather, what we understand is the lived realities of several marginalized communities across the country. And when we say marginalized communities, it could refer to these four aspects: caste, class, gender, and region. As I said, even if it is a religion, it goes back to caste, class, gender, and region. So, at the level of communalism, if you want to see, we can interpret it, but the moment we dig deeper, we identify class as a very fundamental issue. So, anytime you want to study sociology of law or political sociology, understand the different segments within what looks like a complete whole. If you look at this pen, even if it looks simple, it as one unified whole, but it has multiple things inside of this. And as a student of political sociology, your and my job is to look at the different corners of this pen and identify what constitutes of this pen, from where power is getting drawn, whether it is electric power or it is some other kind of power, from where how it is functioning and in what ways somebody understands its functioning. That is the reason why sociology of law is interested in looking at the social structures of a particular context, of a particular society and a particular community. So, it is not just interested in the neutral set of state imposed rules. Rather, it wants to look at how these rules are interpreted and at a particular context, at a particular area. So we have understood what is sociology of law, what is legal pluralism. So now let us come to understand how the founding fathers of sociology have interpreted it. Now Marx understood law as part of the superstructure, because legal codes were created so that there could be an ideological justification of domination and economic domination of the dominant classes. And it was done so, the ideological justification was required so as to present the inequalities or hierarchies in society as neutral and universally applicable. Particularly that is related to liberal laws or liberal interpretation of laws. So according to him, these kind of legal systems reproduce existing relations of production by legitimizing property regimes, labor hierarchies, and patterns of exploitation under the guise of equality. So he calls legal codes as bourgeois law, because what this bourgeois law does is that at the face value it treats everybody as equal. But as we discussed in the previous slide, what we witness is that it is your access to, your reach to legal courts or legal procedures are determined by your class, by your caste, by your gender, by your religion, by your region, so on and so forth. So even if something is being said, the said things requires to be further analyzed. Or in the context of India, what we also need to see is how colonialism codified certain rules of private property and disrupted what was called customary rights on land, which enabled dispossession of peasants, Adivasis, and lower caste groups. The same thing, if you follow Marx's ideas, the same thing is being followed in the post-colonial period as well, because nothing much has changed. The access to land, labor protections are at its lowest level in the post-independence period. And as we have discussed previously, in the case of India, not more than 7% of its labor force is in the organized sector, which essentially means that law in a particular way works only for this 7%, not for the rest 93%. Weber, on the other hand, looked at legality, illegality from the idea of reason and rationalism, or rationalization as a process. That is the reason why he would argue that codified laws seek universality, yet local practices remain heavily shaped by caste kinship, religious norms, which produce hybrid legal arrangements. So even that is the reason why he has spoken about different types of authority: traditional, charismatic, and legal rational. So traditional authority and charismatic authority, they function outside the legal rational order, because they have their own what we call as customary laws, or the charismatic people create their own laws of existence or coexistence. And this process of rationalization influenced the way legal rational processes are understood, the way we conduct ourselves, and the way the society and authorities conduct themselves. Durkheim, on the other hand, looked at law in terms of morality and social solidarity. He would argue that in traditional societies, where there is more cohesion between different kind of groups, what we witness is a certain form of repressive law. Repressive law means that an eye for an eye. If somebody has murdered someone, then the legal course of action is to murder the convict legally. So both of them are killing, One person is killing out of whatever reasons or outside of the law, the second person is killing within the framework of the law. The second aspect of this social solidarity is that of the organic solidarity. In organic solidarity, you have restitutive law. That means, how are you going to give it back? So, giving it back means that uh, the society looks at the collective conscience. A collective conscience would mean here that if somebody has stolen someone else's property or someone else's the commodity, which happens to be the other person's property, then the role of the society through its legal courts is to return the product or return that property to the original owner. Either return that property to the original owner or create a system in which certain kind of penal codes are instituted. You cannot return the 1000 rupees that one person has stolen from another one. So instead of paying that 1000 rupees, let this person stay in the prison or outside of the framework of functional society for 6 months or a week's time. So that way, nobody is getting killed just because they have stolen something, or nobody is getting killed legally or judicially because somebody has uh, angered the king, because we don't have any kings as of now. So that's the reason why Durkheim highlights that law symbolizes collective values, making legal conflict a reflection of broader moral struggles. In the Indian context, there were different kind of legalities that existed in the pre-colonial period, but during the colonial period, the British brought their own ideas of legality from their mother country. But at the same time, they understood that there were certain civil as well as personal laws that could be created for Hindus, Muslims, and others, so that the colonial state with its very small white population can govern or rule over this vast majority of population. 1980s, sorry, 1830s was significant here because since the British started codifying and standardizing of legal rationalization in the Indian context. But within this context also, there were separate laws for Indians and another laws for the whites. So they were not governed by the same laws. The one argument that is made here is that unlike the pre-colonial period, where even if there were personal laws, those personal laws were governed by certain books or certain shrutis or smritis. And for example, we had something called Manusmriti. Manusmriti, yeah, we don't know how many kings and rulers actually followed it, but at least in terms of the book, we understand that it had different different penal justifications or different penalties for different jatis, varnas, and different genders. So for the same kind of act, different jatis and different genders would get different punishments, which was completely nullified with the colonial kind of rational legal codification. But Hindus and Muslims, they were allowed to have their own personal laws. And through these personal laws, inheritance of property, marriage alliances, divorces were structured. That is the reason why what we witness here is the hybrid legacy that shaped post-colonial debates on legal universalism and minority protection. Because even in the post-colonial period, what we witness is that we have something called personal laws, which were supposed to protect the minorities and their ideas about how they can live. Even in the terms of statecraft, we have Article 370 as well as Article 371, which would provide the regional autonomy to certain areas. So while Article 370 was applicable in the case of Jammu, Kashmir and Ladakh, Article 371 is still applicable in most of northeastern part of India. Similarly, the case of 5th and 6th schedule areas where most of the tribal population lives, and they follow not only the laws that are enshrined in the Constitution of India and Indian Penal Code, but also their own customary laws to safeguard their indigenous cultural practices. So personal laws in the post-colonial period continued for religious communities, reflecting political compromises and fears of majoritarian assimilation. And this was done for national integration, because even if we are a newly independent country, the founders of this country, of this republic, understood that we cannot be too insecure about ourselves. We cannot say that, okay, if there are certain customary laws prevailing in certain areas, it is going to disintegrate or destroy the national fabric. They felt that, okay, some groups require certain kind of benefits, so let them give it. But everything has to work within the overarching framework of Indian Constitution. So nothing can move out of this Indian Constitution. You can have different customary laws, but at the end of it, it's the Constitution of India that is paramount. The sociological dimensions of this analysis is that we need to understand how legal pluralism intersects with caste, class, gender, and regional inequalities. And at the same time, we also have to understand how state and non-state legal orders may reinforce hierarchy, but at the same time offer accessible, culturally resonant mechanisms for dispute resolution, like the Khap Panchayats in northern India. So a sociological perspective foregrounds these contradictions as central to understanding contemporary legalities. Upendra Baxi, who is one of the legal luminaries of India, argues that the Indian legal system, even if it looks quite cohesive from outside, it also perpetuates what has been happening since the colonial period. That's the reason why certain groups of people are overrepresented in the overcrowded prisons, and jurisdictions and juristic dependency, as he calls it, highlights India's reliance on inherited colonial structures that perpetuate repression and inequality. That is another reason why we still have capital punishment. That is another reason why we still have custodial violence, political policing, so on and so forth. So in an effect, Baxi's critique exposes how power fundamentally shapes the lived experiences of legality in plural contexts. In the contemporary period, as we will discuss in this week, what we see is that India has been coexisting, or legalities in India are coexisting with personal laws, reforms within these personal laws, tribal autonomy, gender justice, and how customary institutions are part of democratic governance. Or in other words, how the customary institutions create India a functional democracy. Without these customary institutions and without these customary laws and without the recognition of these customary laws, the vibrant democracy that India is would cease to exist, because there would be too much of homogeneity for a population which is considered to be a subcontinent. So with enough diversity that we don't even find within a proper continent. So that is the reason why what we need to understand is that pluralism or legal pluralism is an enduring structural condition rather than an aberration, deeply rooted in India's historical, cultural, and political evolution. So these are a few of the discussion questions that I have mentioned here. One of the interesting aspects is the second question, in which I'm asking, in what ways do caste and class inequalities shape differential access to plural legal orders? Watch out newspapers, look at the YouTube videos, read some of the verdicts that High Courts of India as well as Supreme Court of India gives, and identify the caste and class aspects that are there, and you'd have a better understanding of what we have been discussing today as well as what we're going to discuss in the future. So there are a few references. Please go through them. They are very interesting, and this will tell you about legal pluralism at a much broader as well as in-depth level. Thank you.